So good morning, everybody. My name is Jeremy Travis. I'm the president of John Jay College of Criminal Justice, and I'm delighted to see so many friends and familiar faces in the audience and to welcome all of you to this very important panel discussion at the college sponsored by our Prisoner Reentry Institute. Let me, before I say anything more, acknowledge the work of Ann Jacobs, who's here, the director of the Prisoner Reentry Institute, and thank her for working with the Attorney General staff and others to pull together this really rich and substantive and timely discussion. So the topic today is what to do about people who have been wrongly convicted. And this is an issue that has really captured the imagination of the country, in large part, I think, because of the work of the Innocence Project, and we're delighted that we have a colleague from the Innocence Project here today, Karen Wolff. But it really asks some very fundamental questions about what is justice and how do we secure justice in our country, and how is it that individuals end up being wrongfully convicted in the first place. I'm very proud that John Jay has played a role, and our faculty have played a role in this larger national discussion. We have faculty in our psychology department who have focused on why is it that people confess to things they didn't do. Saul Casson is the principal national expert on that topic. We have faculty who focused on the techniques of eyewitness identification, Jennifer Dysart, Steve Penrod, and others. Faculty who focused on the role of forensic science. In our science department, faculty like Evan Mandery, who's here today, who have focused on the litigation issues surrounding capital punishment in particular. So I'm very proud that our faculty in this institution and our students really have a very deep connection to this larger question. The panelists are, some I've already introduced, but they're referenced in your material, and we'll call them up after the Attorney General's remarks. But let me just say that we're really delighted that we're joined today by Seymour James, the attorney in charge of the Criminal Division of the Legal Aid Society. He's over on this side. Mr. James is well known throughout the city for his work at Legal Aid, on the Sentencing Commission, and other posts. Evan Mandery, I've just referenced, is a member of our faculty, chair of the Department of Criminal Justice. And if you haven't read his book, this is a shameless plug for it, Wild Justice, that looks at the history of the capital punishment issue in our Supreme Court. Has received remarkable, just wonderful reviews. Karen Wolff is social worker at the Innocence Project and has a particular connection to our fourth panelist, Jeffrey Deskovic, who is a student at John Jay, was a student at John Jay, and I will never forget, Jeffrey, the rousing applause you got when we announced that you were in the audience as a graduate at the commencement last year, receiving your degree from John Jay. And he will get to tell his story, but his story is very compelling. So it's my particular honor and pleasure to introduce our main speaker this morning, Attorney General Eric Schneiderman, who is also, I'm pleased to say, a frequent visitor here at the college. We honored him at our gala 2 years ago. It was a great event here at John Jay to commend him for his lifelong work as an advocate for justice. Attorney General Schneiderman is known to everybody in this audience, not just for his work as Attorney General, but for his work going back as state senator. As state senator, what's I think noteworthy here is that this is not an elected official who takes an issue of the moment and says, I want to get involved. This is somebody who's been doing this for years and years and years and working on the cause of justice. So as chair of the Codes Committee of the Senate, Mr. Schneiderman sponsored wrongful conviction legislation, my mistake, to preserve post-conviction DNA evidence, one of the critical issues here, and to mandate electronic recording of interrogations, another important issue. As we see more and more flaws in our system, by looking at these cases carefully, we also come up with some remedies, and he has sponsored that legislation as senator. And then introduced the actual Innocence Act of 2009, to create a legal ground for protesting convictions based on actual innocence. And then when he took office as Attorney General, he did not leave this cause behind. Instead, announced the creation of a Conviction Review Bureau in the Attorney General's office, the first of its kind across the country, and set an example, a leadership example for others, other attorneys general across the country, and has been working with his partners in law enforcement around New York State to really make sure that our criminal justice system convicts those who should be convicted and doesn't convict those who are actually innocent. And what he's announcing today is really the next step in that life's work to provide opportunities for individuals to have very strong claims to receive appropriate compensation when they have been wrongfully convicted. So we're always delighted when Eric Schneiderman comes to John Jay. We're particularly delighted that he asks us to host not just a speech by an elected official, but a discussion. Because our hope is that we can generate a public discussion around these issues that will lead to substantive reform that will make sure that our system here of justice in New York State is as just and fair as it can be. So it's a personal pleasure because I consider us friends, but also just as president, a great honor to be asked to introduce Eric Schneiderman. So please join me in welcoming the Attorney General of the State of New York.
Thank you. Good morning. Thank you, Jeremy, for that generous introduction. President Travis is a friend, and more than that, he is one of the most respected people in the field of progressive, evidence-based reform of the criminal justice system, and as such is a trusted advisor of mine, a leader in policy all across America and far beyond America. The last time I was here, he was celebrating and we were meeting with all of the top law enforcement folks from Uruguay. So John Jay's reach is far and its work is great. And the folks you have here, and Evan, others who I've worked with, I'm really honored. And I'm also have to say, just as a New Yorker, I'm very proud of what's happened to this institution, your growth, your expanse, and your commitment to the intelligent approach, the smart on crime approach, the smart on justice approach to these problems. It is an honor to be here this morning, and I have to say that it's a particular pleasure to be here to talk about the subject at hand, because this is an issue that I have been thinking about for many, many years, and we're joined today by folks who are really in a position to make something happen that should have happened long ago, but there has not been able to really, the reforms haven't been able to take place essentially because of superstition and political cowardice, if I may be candid, because I know nothing I say here will leave this room. So this is an issue that, these are issues relating to wrongful conviction. I've been thinking about since I was a deputy sheriff in Berkshire County, Massachusetts, where I spent 2 years between college and law school working in the Berkshire County House of Corrections, and for the first time in my life met someone who had been incarcerated for a crime they didn't commit. And it was a fascinating process because both the law enforcement folks and the prisoners had the exact same rationale for why this was okay, which was, well, maybe he didn't do this, but probably did a lot of other bad things. And the prisoner would say, yeah, I got away with some other stuff, so oh well. That's not the way our justice system is supposed to work. And in my view, my job every day is working for justice. And again, this is something that is not new to me as Attorney General. I finished working in the prison. I went to law school. I came back and I was a law clerk in the Federal District Court here in Lower Manhattan. I went into private practice and did a combination of civil and criminal work, and then gradually started doing more and more public interest work and became the pro bono partner of the firm. Realized I really wanted to do public service, went into the state Senate, and then had a very, very close experience for years with the people who were in fact putting up the barriers to progressive evidence-based reform of the criminal justice system. And I met a great partner and this person who will be sponsoring the legislation I'm announcing today in the Assembly, Assemblyman Joe Lenthal, who had been fighting these fights long before I got there. And together we were actually able to accomplish some very good things. And with this legislation, I think Joe and I are going to accomplish some more very important things together. But in my capacity in the state Senate, I served on and eventually chaired the Codes Committee, which Joe is my counterpart in the Assembly. And that's the committee that deals with criminal justice and criminal procedure issues. And we were able to accomplish a lot, but it was an uphill fight all the way. It took decades of organizing by thousands of people before we were in a position and I'm proud of the fact that I did this as chair of the Codes Committee, to repeal the Rockefeller drug laws. Decades of working just so the most common sense reforms could be enacted to laws that everyone understood were not having a positive effect, but people were just afraid to vote to reform. Politicians across America, not unique to New York, are terrified of voting against anything that could be in any way, shape, or form be construed as being soft on crime. As a result, we have had decades and decades of laws passing. They're not tough on crime. They're dumb on crime. And we've gone from a country, when I was working back in the prison, maybe there were 300,000 or 400,000 people in all the jails and prisons in the United States. In the last decade, when we hit 2.5 million people in prison, even some of the more conservative commentators out there started to say, you know, we've really got a problem here. We have 5% of the world's population, 25% of the world's prisoners. So these are issues that, to me, frame up the movement that is building here, in which John Jay and Joe Lentil, and I hope I, are parts of, which is, again, about progressive evidence-based criminal justice reform. And I say evidence-based because, and we see this today in this sort of pushback about the notion of making higher education available to prisoners, which is a no-brainer. There is not one piece of data that does not suggest it's a great thing. Again, it's an approach that I feel like we're back in the same fight they were in hundreds of years ago. You know, when Beccaria wrote on crime and punishment, the whole idea of the book was we shouldn't be basing our system on superstition. We should be basing it on evidence. That was many hundreds of years ago, and sometimes I feel as though the same willful ignorance is what impedes our progress. So, as Attorney General, I've often noted that my guiding principle is equal justice under law. To me, this is our most quintessentially American ideal. It is the underpinning of our democracy. When there is injustice, it is our obligation, my obligation, but all of our obligation, to try to remedy that injustice. That is the American way. And it's hard to imagine an injustice worse than being sent to prison for a crime you did not commit. Not only is an innocent person wrongfully denied freedom, the victims of the crime are really denied justice, and the real perpetrator is still free. This is a lose-lose-lose proposition. But there has been a tremendous reluctance to accept the fact that there are many people in our system who are doing time for crimes they did not commit. And it's time for us to look at the facts rather than the superstition, to look at the evidence rather than the political pressure, and address this issue. For the wrongfully convicted, a lengthy prison sentence is usually devastating. Jeff Deskovic is an unusual case in many ways, but the fact that he's been able to pull himself together, get everything back on track in his life, it's a reflection of the quality of the man. But most people do not recover that well. People have their careers destroyed. They lose years of income. They lose time from their families. Often the ties with the families are weakened or severed. They miss years of their lives that can never be reclaimed. And that is why Section 8B of the New York State Court of Claims Act allows people who are found guilty of a crime, imprisoned, and later have the conviction overturned to present a claim for damages to the state. This statute's been around for a while. It makes sense. People who are wrongfully convicted should be able to seek compensation for their unnecessary sacrifice and to get their lives back together. But under the law as drafted, certain people are excluded under Section 8B from suing the state after having been wrongfully convicted and incarcerated. Section 8B allows such claims only if the person, and I quote, did not by his own conduct cause or bring about his conviction. So there's a barrier to recovery. And that phrase, the person has to show that he did not cause or bring about his conviction. This has been interpreted to restrict claims by those who falsely confessed or made admissions or pleaded guilty to crimes they did not commit, but who cannot prove that their confession or admission or plea was the result of duress or coercion. The burden of proof right now is on the wrongfully incarcerated plaintiff in this case. They're coming into court to get monetary compensation, and there's this huge barrier in front of them. The statute, as written, includes, in my view, an unnecessary and overly broad barrier that disregards certain extenuating but all too common circumstances for false confessions, admissions, and pleas. It doubly victimizes people who acted out of fear, had a serious mental or psychological problem, and were simply too young to know what they were doing, and as a result, they admitted doing something they did not do. This happens a lot, and the reluctance to accept this fact is extraordinary. I remember being in the Senate, and we had a whole group of people who had confessed to crimes they didn't commit and were then exonerated by DNA evidence, absolutely 100% clear they didn't commit the crimes. Completely clear they had, for whatever reason, confessed to a crime they didn't commit. And I remember having them up in the balcony of the Senate when we were debating one of my bills. And then I remember one of my colleagues in the Senate standing up with these people standing there, and he says, well, no one actually confesses to a crime they didn't commit. And I'm like, what else do I have to do here to explain this point? I have them here. And yet that senator said those words. It is willful blindness, ladies and gentlemen. So today I'm announcing, and I'm proud to be doing this with my longtime partner in the work for justice, Joe Lenthal, that my office will be submitting for introduction a bill, the Unjust Imprisonment Act, that will change our state statutes so that someone who falsely confesses or pleads guilty and later has that conviction overturned may still pursue a claim for damages even if the person can't prove that the confession or plea was coerced. Joe is going to be sponsoring the bill in the Assembly. We're speaking to people in the Senate, and I have to say once again, when I got into the Senate, Joe was a mentor to me in understanding why in Albany A does not lead to B. Sometimes A leads to Q, R, Z, and D before you can get to B, but a great, great fighter for justice for many, many years. I've had the pleasure of working with him on a lot of issues, and I'm looking forward to working with him because it will take work to get this legislation as sensible and prudent as you may view it, as essential and unremarkable as you may view it. It will take work to get this passed. This bill will also eliminate other procedural barriers that impose undue burdens on those who seek to file claims against the state after having been victims of unjust conviction and imprisonment. First of all, for whatever reason, the statute of limitations for pursuing these claims is shorter than almost any other statute of limitations for a claim against the state. Our bill is going to extend the statute for filing these claims from 2 to 3 years, as most claims that go to the Court of Claims are. I mean, it's really remarkable, again, that this one category of claims has been singled out to have a tougher burden. There is no reason for us to impose this additional burden on people who've been wrongfully convicted and imprisoned. Our bill will fix that. And we're going to allow people whose cases were dismissed for constitutional violations or for certain serious defects in the criminal process, which are not currently permissible grounds for recovery under 8B, our bill will allow them to now be eligible to seek relief. Again, all we're talking about is letting people bring their claims. They still have to show that they didn't commit the crime, and they have to show that they deserve compensation. The problem now is the way the statute is structured. These people don't even get into court because of these unnecessary barriers. The changes, again, they should have been made a long time ago when we were fighting on this subject back in 2009, 2010. We had an opportunity. It's time to change these laws and open up the courthouses to those who were wrongfully imprisoned and convicted. And another change we're making in the law in this legislation relates to a case, and one of our most vocal supporters for reform of Section 8B, another wrongfully incarcerated person who became an advocate for reform, is a guy named Fernando Bermudez, who served more than 18 years for murder before he was exonerated. Now, listen to this situation. It is in my office. It's in my inbox today. Today, Mr. Bermudez is seeking damages from the state for being wrongfully locked up for 18 years. And because of a fundamentally unjust technicality in the law, my office is obligated to fight that claim. This is a fight no New York State Attorney General or anyone else in our law enforcement system should be required to engage in. I believe he should have his day in court. Unfortunately, under the statute, there is a stricter verification requirement where you verify that all the facts set forth are true. There's a stricter requirement for filing a claim against the state for unjust conviction and imprisonment than for any other type of case. Mr. Bermudez seeks to recover under Section B for unjust conviction and imprisonment, but under the existing law, he had to personally verify the claim. Rather than have his attorney verify the claim, which is permissible in most other cases, Mr. Bermudez's claim did not comply with this requirement, and it is now the job of the lawyers in my office to challenge his case and seek that he be denied his place in court. The changes we're proposing today would, in fact, and they're to be made effective as of the beginning of this month. If these changes go into effect, Mr. Bermudez will have an opportunity to correct his attorney's mistake and get his day in court. He's not the only one doubly victimized by the law. New York State, ladies and gentlemen, has unnecessary barriers throughout the system. I've identified a few today in the area of wrongful conviction and imprisonment that we are going to seek to address in this specific legislation. But there are other problems out there that we have to move on to address, and we look forward to the discussion today opening up some new prospects and possibilities for other reforms. New York State is number 3 in the nation in the number of convictions overturned by DNA evidence. Since the year 1991, 27 people have had their convictions overturned because of DNA evidence in New York State, and 10 of the 27 also falsely confessed to these crimes. So they didn't commit any of these crimes. Jeff Deskovic, who will be a participant in the panel a little later, had an issue with this. These 27 people served an average of 11 years in prison. These are people we know did not commit the crimes. According to the Innocence Project and the National Registry of Exonerations at the University of Michigan Law School and Northwestern University School of Law, 37% nationally, 37% of those whose convictions were overturned through DNA evidence, and this number I think is actually the number is a little bit higher than nationally in New York State. We're up 37, they're a little lower. But nationally, we're talking about a lot of people, high percentage of people wrongfully convicted who confessed to crimes they didn't commit, 37% in New York. The reasons for these false confessions and admissions of guilt are complex and as varied as the defendants themselves. Some involve young people who were easily intimidated or unaware of their rights. Some defendants were clearly suffering from some mental defect or disability. But to me, that's totally besides the point. When we're talking about Section 8B, about your right to recover monetary damages when we know you were wrongfully incarcerated, all of these people who are barred for all of these technical reasons from getting their day in court, giving a chance to prove that they're entitled to compensation, all of them have already persuaded another court that they didn't do it. Keep in mind, you can't get into a case under 8B and ask for compensation from the state unless another court has found that your conviction should be overturned or vacated or sent back for a retrial or something else. These are not, this is not open the gates to people who say, you know, I did time and now want to maintain I'm innocent. No, you've had to have a court look at the whole criminal case and make a determination before you get in. Why should we have these additional procedural barriers to prevent people from getting their rights? This is unusual that a prosecutor is coming forward to say, I have some extra defenses here, but I really would like to give them up. But sometimes you have to be smart and you have to look back to the point of our system, which is to do justice. My office has to defend the state against these claims. So this is not an issue I raise lightly. We've thought about this and worked on this and kicked around language for many months. But as a state and a society, we must deal fairly with people who have been dealt with unfairly by our criminal justice system. We must admit to errors. This is not an attack on the American system of justice in any way, shape, or form. This is an effort to carry out the tradition of the American system of justice. Our criminal justice system has changed over time to accommodate new technologies, but also new understandings of the workings of the mind, evolutions in legal theory. We make exceptions in our criminal laws, rule, and procedures. We make exceptions for all types of extenuating circumstances. Now, we must allow the law to reflect greater wisdom and greater compassion for those who, for a variety of reasons, act against their own interests or make simple mistakes that prevent them from getting their day in court when they seek recovery for as grievous an injustice as we as a society can inflict on anyone, wrongful conviction and incarceration. We must fix this fundamentally flawed and outdated statute that is currently written stands in the way of justice. The people we are seeking to help have paid a debt they did not owe, ladies and gentlemen. it is important for those of us who work in the justice system to make good on the debt we owe them. With your help, I look forward to getting this bill passed. It will take some work. Joe can explain to you all the reasons why, but we are very determined to do this. We're here at John Jay because you are true leaders in this movement, in this reform movement that is emerging all around America. We need the support of the reformers to get this through the state legislature. I am determined to do it. I'm determined that we do justice, ladies and gentlemen. We need your help. Joe and I need your help, but the people of the state of New York need your help, and this says a lot about our society. If we can do this in New York, we can set an example for the rest of the country. So with your help, we're going to do this. Thank you very much.
So we'd like to invite the members of the panel to come up. Mr. James, Ms. Wolff, Ms. Deskovic, and Evan Mandery, who I saw somewhere. I want to take this moment to make a special welcome to Joe Lentol, who's also a good friend of the college. As the Attorney General said, has been a long champion for justice as chair of the Assembly Codes. And it's nice to see you here, Joe. Just a wonderful day for John Jay. You're on, right? I'm on. So let me introduce Ann Jacobs, who's the director of our Prison and Reentry Institute, well known in the justice reform world, former director of the Women's Prison Associations, worked at the Criminal Justice Coordinator's Office, many positions before coming here, and we're very lucky she's here, and she gets the credit for putting this together, and she gets to moderate the panel. So thank you.
Thank you. Good morning. It really is my pleasure to be here with you. I want to thank the Attorney General for choosing John Jay to make his announcement today. Obviously, we have a room full of people who already care about this issue. We hope that the panel discussion that we're about to have can further expand all of our understanding of the complexities of what's currently happening and what could constitute better practice. Excuse me. I'm not going to reintroduce the panelists. You were introduced to them by President Travis earlier on. But rather, we're going to start with short remarks from each of the panelists, and then our goal this morning is discussion. Discussion among the panelists and discussion with you. So I hope that we are able to cover a lot of territory. And before we go any further, I just want to thank Mindy Bockstein, who has been my partner in putting this event together. Mindy is the Executive Director of External Affairs for the college and was actually much more involved in producing today than I was. So thank you for giving us the opportunity to do this. So first we're going to hear from Dr. Mandery, and then we're going to hear from Seymour James, then Karen Wolff, and then Jeff Deskovic.